Right, our next speaker, Gerard McDermott, who really needs no introduction. Star individual under Chambers and Partners and directories, been practicing in PI at the highest levels for as long as I can remember. He's going to talk to us about running group claims. Gerard, are you going to do that separately first, or do you want to bring in the panel?
I'll do that first and I'll bring in the panel.
Okay, I'll leave it to you. So, Gerard, thank you.
So, first of all, thank you very much for coming to this. Thank you to Bob and Kevin and Joel for making the trip across from America. And I'm glad to be here talking to you. I, these days, am really a plaintiff lawyer. It wasn't always that way. I used to work for both sides. I think Aviva in particular, about 10 or 15 years ago, said they couldn't use me any longer. I've always thought that's because I took so much money off them. But my approach to the law, dealing with very badly injured claimants, has, I can tell you, been very much conditioned by the fact that American law, an American trial lawyer in particular, and working with American trial lawyers, has conditioned my approach to this. Bob Clifford has been a friend for more than 25 years, as has Joel, and year on year I've gone across there and learnt how to do things better. Just as a footnote to what Sarah was saying, I've known that our group litigation system is really woeful compared to what it is in the States. It's something that Bob and I have looked at many times. And also, forum non-convenience in the States works against us quite harshly. And again, we've looked at bringing claims in the States. It's never seemed to me unfair that American manufacturers should have to be sued in their home courts. That is, of course, something of a simplification, but it is my starting point. I just want to take a moment, if I may. I have been involved in the Grenfell Tower litigation, and we've all, as lawyers, agreed really not to talk about that a lot. It's not a marketing point, but I just want to mark that today is the day that the second and final report has been published, and it shows how widespread and how woeful all the failings were that led to that extraordinary disaster. And whether it's an aviation accident or crash, accident perhaps isn't the right word, if it's an aviation disaster or a disaster like Grenfell, or actually many of the individual catastrophic injury claims that I get involved in or we get involved in, it's really important to have proper redress. And although it's never sufficient, because I don't have any clients, I've never had any clients who would rather have the money than be uninjured. They would all rather be uninjured, or their families would rather they were alive. And again, I've discussed this with Bob in particular for many years, the economic recoveries in bench trials in England and Wales are in many respects quite satisfactory, but it's the non-economic loss. It's the wrongful death claims where you get less than £15,000 for a bereavement, where if you don't fall in the right category, you get nothing, actually, that I feel as a plaintiff lawyer we have to improve. So I'm sorry, that sounds like a bit like a sermon. I am fairly driven, but I'm really pleased to be doing this. And I just wanted to talk a little about managing the claim. And so I've spoken to this, really. What's my perspective? My perspective is personal injury and clinical negligence for more than 30 years. I've always had an eye about product liability. I've always had an eye to the US as a forum. I've been active in the American Bar Association for 35 years. And I've learnt a lot from them. And I've learnt a lot about the importance of group actions. And very often it is about holding corporations to account. And that's why I was delighted that Kevin and Bob were able to make it across, and that Joel sees this as well from a defendant perspective in terms of the way things are done in the States. So, not going to talk about detail at all, but I have learnt a lot over recent years. And I've learnt one of the things that you need to do if you're managing a claim for a large number of claimants with very often multiple solicitors. I suppose before I did group litigation, I wasn't sure what steering committees did. I know now. They keep it on track. They keep people informed. They keep the defendants informed, and actually defendants need to have steering committees effectively as well, so that they are informed as to how things are going. I learned about the importance of common counsel. I was very lucky in the Grenfell Tower litigation to jointly lead that litigation with Richard Hermer, who is now the Attorney General, who probably knows as much about group litigation as any other silk in the country. And when he was appointed, I can tell you, I knew there'd be some pushback because he wasn't in Parliament. I knew there'd be some pushback because Keir Starmer knew him very well. And I simply tweeted what I knew was to be correct. He's the finest silk I know, full stop. And he's developed the law in many of these areas. If you're a claimant lawyer, and again, actually, for the defendants who have to meet these claims, you have to meet regularly, you have to keep people informed and keep others informed. A basic point, that you need good minutes and agendas so that when you go back over 2 years to see how you came to a decision and what you intended by it, that you understand what lies behind it. Actually, you need someone taking a lead on correspondence with opposing parties and the court. And Isabel Bathurst is one of the solicitors who instructed me on Grenfell Tower, so she knows what lies behind these comments. But I think it's also important for the defendants to understand that this is in place. The defendants, and we're going to talk briefly, perhaps for 15 minutes, about how defendants and how corporations can react better to crises like this to the benefit of the company and to the benefit of those affected by it. But it's important for the defendants to know who they're dealing with and that those that they are dealing with are people that they can have a rapport with, but also that they are truly representative. So that's one of the things that I've learned. Use of counsel. This is not actually a plug for our temple specifically, though part of it will be. I think that although in many respects I've wanted to change the bar for years, everyone knows that, or everyone who knows me knows that, but one of its strengths is the ability to choose counsel for your case. And I'm looking at some of the solicitors in the audience who instruct me. And I know that I won't always be the counsel for their case. It'll take a mix of skills, it'll take a mix of interpersonal skills, of knowledge and experience and so on. And I think from both sides, you know this already and I'm sure you do it, choose your counsel wisely, I suppose, and see how they fit the case. I've learned there'll often be a lot of work. I learned there'll be a lot of correspondence, there'll be a lot of detail, there'll be a lot of witness statements and a lot of issues to consider in the complex cases. And I've learned that you've got to put people together that can work together. I've never had a better working relationship with anyone than I had with Richard Hermer in Grenfell Tower. But actually, in discussing it with various people, I've heard that sometimes that's not always the case, and it doesn't sit very easily. But importantly, you've got to work and play to your strengths. And it's not just experience in the field. Sometimes it's client management skills. The one thing that's common to anyone who has to deal with catastrophic injury or disaster is how vulnerable, angry, and concerned their clients will be. And again, that plays into the question of how corporations react to disaster. And in medical device claims, I know that we have some here from the firms that will handle those for corporations and so on. I see, of course, that product liability from a defendant perspective may be a little bit different than from a claimant perspective because, of course, there are commercial considerations. In many cases, it'll be a really big issue for the company. But if you're dealing with medical device claims, you don't want someone just with group litigation experience. You probably want someone who's got clinical negligence and experience of running personal injury claims because it may be in the group litigation context, but they are essentially personal injury claims. So that's one of the things, some of the things that I'd learned. Keeping track of the case. When I was first asked to become involved in this case, I'm not sure I realised how much volume there would be and how long it would take. But it's part of the role of the steering committee. And actually, I think contact points for opposing parties is really important. I think it's vital. And keeping clients informed is not something that I generally have to concern myself, but dealing with inevitable queries and dealing with parallel proceedings sometimes is important. I mean, in fact, in Grenfell, we did try and start in America, and we started proceedings in Pennsylvania, and we made it to the Third Circuit. Naturally, at first instance, the judge thought it was forum non-conveniens, and that was affirmed by the Third Circuit. Gathering information. Actually, from a claimant point of view, I've learned how important it is for defendants to have information. They need to know what the level of their exposure is, and their insurers need to know what the level of exposure is, and that will often help them to meet the claim as we progress it. Of course, it's also important from the claimant's point of view, so you know what you're dealing with and what the level is that you're dealing with. You might not need everything at the start, but you do need to know what the shape of the case is going to be. You need to have an idea of what the value of the case will be. That's going to be important for corporations and their insurers and reinsurers and so on. And you need to know what more may be needed. So I suppose one important thing I've learned is that information, you need to have it, and you have to have it properly organized. Costs and cost management. It's key to deal with this at the outset. From a claimant point of view, ultimately you might have to face detailed assessment. From a defendant view, I'm sure your corporations and insurers want an idea of what it's going to cost on both sides. From a claimant point of view, ensuring you've got CFAs, AT insurance where proper, where necessary, and clear funding arrangements, and keeping track of them too, actually. But perhaps the most important thing, there are two important things I really learned from all this. One is managing a case where there are multiple defendants. And there were multiple defendants in this case. There will be issues between them. Whatever the nature of the tragedy, for an insurer, they're actually going to be looking at what will it cost me? How much can I pass on to other parties? And actually, it may be as difficult trying to apportion liability between them as it is to reaching agreement between the claimants and a group of defendants. And that's something I learned and was very important. So actually, that's why I would always encourage, if you've got multiple defendants, for them to get some structure at the start. But probably not by lecturing them, that doesn't tend to go down very well, but encouraging it. And dialogue. So again, this comes back to counsel. In that case, there were very good dialogue between solicitors, but actually, sometimes a group of generally 4 of us leading counsel, we had a very good rapport, and that helped us navigate a lot of things, and we could just detach ourselves from things a little bit and move things on. And that really is my next slide. A core group of counsel representing all parties may make things smoother. But here's my key point. And it was driven home to me, actually, at an aviation conference run by PEERPL, the Pan-European Organisation of Personal Injury Lawyers, last year in Paris, which Bob was speaking at and had sponsored. And I sat there, and actually we'd just been through ADR in the Grenfell case. And I listened to quite a lot of defendant aviation lawyers, and 1 or 2 of them were explaining what sort of technical points they would take to undermine a claimant's case, how they would take a technical point to slow it down, and so on. And I couldn't resist standing up and saying, you know, whatever kind of disaster it is, you're dealing with people who've either lost a loved one or more than one loved one, or you're dealing with a community that's been shattered, or you've been dealing with someone whose life has been either ended or changed. So I recognise that defendants have got a case to defend, and I recognise they will want to use appropriate tactics. I also recognise that it's adversarial. But where there is a disaster, if it's a disaster in which the route to success for a claimant may be clear, my view, my advice would be where you can see there's been significant harm to a large number of people, actually significant harm to anyone, look at ADR from the outset. This is public, and I can speak about it. Throughout the Grenfell litigation, once we started proceedings, we made it plain that we wanted to enter ADR. And again, I can't talk about the details of it, but I learned a lot about how to do that. And actually, you might actually need, in the bigger cases, ADR and mediation about what the dispute resolution process will look like. And that's one big takeaway. And again, this is sort of moving into the final 15, 20-minute slot about how corporations can respond to disaster. And actually, one may be, why don't you look at it through the eyes of those who've been injured? And what are they expecting? And how can you manage those expectations? And how can you meet them, actually? And how can that be used to deal with the disaster that your company may have been partially responsible for? I thought it was fascinating to hear from Bob and Kevin about how people had, how they dealt with Boeing, and how Boeing, by the sound of it, didn't behave terribly well to begin with. Of course, we also know it's why you need well-funded plaintiff lawyers to hold them to account. So where do you start with ADR in the more complex cases? Well, maybe initially you start with how it's going to be managed and how collaborative you can be. It is plain that the defendants may need their own ADR to deal with apportionment. And what I do know from more than 25 years dealing with the most serious cases of individual personal injury is that actually a collaborative approach in those cases is the rule rather than an exception and benefits all. I have any number of cases currently and in the past where insurers have realised they're going to have to pay very significant sums out, and maybe if they were nice to the claimants the way through, and maybe if they helped them with a big £1 million interim payment to buy the house they need, and maybe if they funded the care that was going to be required, it might lead to a resolution sooner rather than later. So I can think of one case at the moment where probably going to be able to conclude a very, very significant case within 2 years. That will save costs. It enables my client to get on with his life. And it resolves litigation, because actually our clients may be very respectful, but actually they don't really like having lawyers in their lives for longer than is necessary. I also think maybe appoint the right mediators at the outset, and I think that all of that will benefit everyone. Again, I said I wasn't going to talk about the case, but this is public. David Newberger in particular, who mediated that case, is just outstanding. I know he's also now mediating the Manchester Arena bombings cases, and he's just exactly the right fit. And those really were some of the lessons I've learned about managing group litigation. I think 15 minutes is probably enough. And I thought that what we might do now is just to close today, a shortish session, I think, really, on how corporations might react differently to a product crisis.